This program is brought to you by the Practicing Law Institute, a nonprofit learning organization dedicated to keeping attorneys, professionals, and accountants at the forefront of knowledge and expertise.
Hello and welcome to the inSecurities podcast, keeping it fresh and staying wonky on the latest securities, regulatory, and enforcement developments with a practitioner's perspective on the stories you should be following. As always, I'm Chris Eckemoff, and I'm here with my co-host, Kurt Wolf.
It is very good to be with you again, Chris, for another exciting episode of the inSecurities podcast. You know, I think one of my favorite things that we talk about sometimes on the show, and we actually did a dedicated episode on this a few weeks or months back, is the intersectionality of things happening at the Supreme Court and things happening at the SEC. And I think it's a fun little space for us to talk about, or for our listeners to kind of tune in, because sometimes the things that are happening at the Supreme Court really do impact what practitioners are doing and thinking about every day, what some of our clients are doing and thinking about every day. And plus, it's just been a little more interesting or colorful, I think, over the last few years to see what's happening at the Supreme Court. So wanted to return to that topic today.
And I think, Kurt, we'll probably have a little bit better analysis and update based on our guest today than you and I kind of sharing our armchair quarterbacking of Supreme Court decisions.
No doubt.
Well, we'd like to welcome our guest today, Adam Liptak, who covers the Supreme Court and writes Sidebar, a column on legal developments for the New York Times. Adam started at the Times as a copy boy after graduating from Yale, where he worked on the school paper. He returned to Yale for a law degree and then practiced law for 14 years, concentrating on First Amendment issues, including several years in the New York Times Company's corporate legal department. Adam joined the paper's news staff in 2002 and started covering the Supreme Court in 2008. He was a finalist for the Pulitzer Prize in 2009. As a journalist, Adam's goal is to make the Supreme Court accessible to readers, and today we'll lean on him to make the Supreme Court a bit more accessible to our co-hosts and to our listeners as well. Mr. Liptak, welcome to the inSecurities podcast.
It's great to be here. Thank you for having me.
So, Adam, as we've mentioned, we really focus on things happening at the SEC, developments in the securities regulatory enforcement space, things happening in the accounting world. And, you know, my impression is that over the last several years, the SEC has itself appeared before the court with greater frequency, I think, than in recent years. There are, of course, a number of blockbuster SEC cases from decades or years ago. We've talked about some of them on the show before. But just in the last few years, we're looking at cases like Kokesh, Lorenzo, Liu, Jarchese. I would put Digital Realty in that bucket as well, even though the SEC wasn't one of the named parties in that case. So I guess, you know, basic principle, would you agree that maybe the SEC is appearing before the Supreme Court with greater frequency? And if so, do you have a sense why that might be?
So let me step back and say that I'm a journalist and I'm a generalist. I follow the court's work pretty closely. I have no particular expertise in the SEC. Years and years ago, when I was a law firm associate, I did a little securities litigation, but I'm the furthest thing from an expert on this stuff. And I'm not sure, Kurt, that I can tell you empirically. I guess if forced, I'd say I don't share your intuition. I'd say the SEC is appearing in every second or third term. And moreover, my sense is that the issues the court is interested in vis-a-vis the SEC are as often as not structural issues about independent agencies that happen to arise in the context of the SEC, but are not truly about or only about the SEC. So questions about what's a public right, what kind of equitable relief can be sought in an enforcement proceeding. Those are interesting and important questions and arise in the context of the SEC, but the court's interest in those questions cuts across many administrative agencies, or at least that's my impression.
I think that that's probably right. I do think that the SEC is a party in a lot more cases than it has been in other periods of time. But your point is well taken. And I think it maybe is administrative agencies more broadly, because we do see cases against, the FCC and the CFTC and the EPA and, there's sort of the alphabet soup of Washington, D.C. agencies. So, I mean, do you think that is that fair? Is there more of a focus, or are litigants maybe perhaps more focused on the administrative state? And is that just working its way up to the court?
I adopt that view completely, and maybe would push it even further than you. The recent justices, the Trump appointees, Kavanaugh, Gorsuch, and Barrett in particular, but also Alito and Thomas, are very interested in what has been, of course, a long-standing project of the conservative legal movement to rein in the administrative state across many dimensions. And some of the cases we're talking about fit that pattern well. The court is just uncomfortable with the power that agencies have. And Jarkesi is a prime example of that. They looked at a key enforcement tool of the SEC of whether it can bring cases in its own administrative tribunals. And you read the decision, it happens to be in the context of securities regulation, but it's really a question of what adjudicative power should any agency have, and in what settings do defendants have a right to a jury trial? And those kinds of issues are of deep interest to this court.
Yeah, it sounds to me, Adam, that you could take a very narrow view of Jarkezi and focus only on the administrative proceeding element that is brought in that case. But another element may also be just considering if it's a fraud charges only type of decision. But to your point, right, those broader questions seem to be what's really at stake with what the court's interested in hearing in its most recent terms.
Yeah, that's how I see it. But again, I may have a blind spot here. There may be other themes that run through these cases.
I mean, you mentioned the makeup of the current court and some of the appointees to the court over recent years as maybe playing in a sense to the types of cases that they're taking. But I wonder how, at the lower court, at the federal circuit courts of appeal level, does it matter there too? Are we seeing more cases maybe becoming ripe for cert to the Supreme Court because folks are going, disproportionately to the Fifth Circuit or the Ninth Circuit, trying to create an issue that is ultimately appealable to the Supreme Court?
You're absolutely onto something. I suppose there's a little bit of equivalence here about the Ninth Circuit, maybe. But really, the story is that very aggressive challenges to the administrative state are brought before single division judges, so you know what judge you're going to get. You're very likely to get that outcome in Texas. And then that will be appealed to the Fifth Circuit. And the Fifth Circuit has developed a recent reputation for a kind of extremism, outlandishness, ability to find itself well to the right of a very conservative Supreme Court. And a good example of that is the CFPB case in the last term, where the Fifth Circuit, I paraphrase, but it's fairly close, in looking at the way the CFPB, the Consumer Financial Protection Bureau, was funded. The Fifth Circuit says, well, we're not sure where the line is, but this has crossed the line. And that gets to the Supreme Court. And the challengers lose 8-1 in an opinion written by Clarence Thomas. And if you've lost Thomas in a case like this, your case had nothing much going for it to begin with. And yet it was endorsed by the Fifth Circuit. And so your point is quite right that this kind of forum shopping kind of creates work for the court, that they have to clean up some of these messes. That's not to say the Fifth Circuit always loses. It loses a lot. But, in some major cases, they also, reset the balance on some of these issues.
Yeah, that's one of the interesting things, Kurt, I think you've educated me on over the past few years is the role of some of those maybe less foundational legal arguments in kind of finding where those lines are drawn, whether it be through the appeals process up to the Supreme Court or just in some of the cases brought that we've talked about, where on their face, right, the arguments may not appear to be valid or supported in certain ways, but even asking those questions can sometimes lead to a legal discussion of where those lines should be drawn. Adam, I want to talk a little bit about some of the writings you've done in recent history and some of the things we've talked about on the podcast as well over this year. Over the summer, in an article for the New York Times entitled, "In a Volatile Term, a Fractured Supreme Court Remade America," you wrote, quote, "Administrative agents had a horrible term. In three 6-3 rulings along ideological lines, the court's conservative supermajority erased a foundational precedent that had required courts to defer to agency expertise, dramatically lengthened the time available to challenge agencies' actions, and torpedoed the administrative tribunals in which the Securities and Exchange Commission brings enforcement actions." End quote. We've talked a bit about kind of your thoughts on the administrative challenges coming through the Supreme Court, but specific to kind of this 2024 period, how do you feel that the sea change is happening towards administrative agencies?
I just want to pause and say, yeah, that's a pretty good sentence I wrote.
Excellent work by whoever wrote that, right? I think it reads wonderfully.
It was.
I mean, the big headline, and this is huge, was overruling Chevron. So in the previous three terms, you had 3 terms ago Dobbs overruling Roe v. Wade. You had the Harvard and North Carolina cases doing away with race-conscious admissions in higher education. And then you had Chevron, and all 3 of those overrulings are incredibly significant. And the consequences, I mean, just to make sure we're all on the same page, the Chevron doctrine, a foundational doctrine of administrative law, says that courts should defer to administrative agencies when the agency has reasonably interpreted an ambiguous statute. And that can do a lot of work and makes life easier for judges who are not experts in technical things. They can go with the agency's view. But it is a conception of agency power versus judicial power that really rankles 6 members of the court who think that these decisions ought to be made, first of all, by Congress. Congress should speak clearly, and the agency should execute what Congress said. But to the extent there's an ambiguity, that ambiguity should be resolved by judges, not agencies. And there are strong arguments on both sides. John Marshall said that it's up to the courts to say what the law is, not up to an agency, not up to an unelected bureaucrat. At the same time, it's just unrealistic to think that generalist district court judges can know the intricacies of food safety and securities regulation and environmental regulation and all kinds of stuff. So having done away with this idea that there's deference to agencies, we're now in a new world, and we need some empirical data, which we'll get over the next couple of years, about how much of a difference this makes. Because after all, just because you're not required to defer to the agency, you may well still defer to the agency because you find it persuasive. And that's going to be the case sometimes. There may be times also where Congress did give not only substantive guidance on the answer to the question, but authentic deference legislatively conferred to the agency. So we're going to learn a lot about whether this was symbolic or practical. Challengers certainly hope that a lot of regulations will fall. People on the left are terrified that the nation's food safety and environment and consumer law and securities regulation will be different. But it's too soon to tell. Let me add for just a beat that it's a hell of a thing that even as the court was striking down the Chevron doctrine, it issues the corner post case, which says the statute of limitations on challenges to regulations starts to run each time an entity is subject to that regulation. So if you, years after the statute of limitation had ordinarily run, start a new company, and that company is subject to the regulation, the statute of limitation starts again. And in combination, those two cases, Corner Post and Loper Bright, the Chevron case, really have the potential to upend the structure of American administrative law.
On that note, Adam, I'm interested as the non attorney on the podcast here. When the court considers some of these more foundational legal standards, is there any weight given to the importance that they serve in the legal system? I think I've read somewhere that Chevron has been referenced more times than any other kind of legal standard in the same relevant period. Should the court be considering the difficulty of a change or should they not? I'm interested just as a follower of the court.
That is absolutely a consideration. Whenever the court considers whether to overrule precedent, it looks at a number of factors. One of them is the reliance interest. Have people gotten used to this way of operating, and will this cause a huge disruption? And the court said, no, this is fine. It's going to be workable. The decision was so profoundly wrong when decided that so you tick off these boxes. Was it really wrong? Were there reliance interests in it? Has it been undermined by later decisions? Are there workability problems? And of course, the dissenters said the majority hadn't begun to satisfy those stare decisis factors.
Mhm.
We've been sort of dancing around Loper Bright a little bit here, talking about the fall of the Chevron doctrine, and I want to talk a little bit more about Loper Bright. But I guess I'd be interested in your view on why now with respect to Chevron. I mean, there have been rumblings for years that the court was going to strike it down or narrow it or somehow restrict its applicability. I mean, I mentioned earlier the Digital Realty case. Many thought at the time that that could be the case, and instead it was sort of reduced to a footnote, as I recall. And so I wonder if it has something to do with the current makeup of the court or the specific facts of Loper Bright. I mean, why now? If people have been waiting for this for quite some time, what happened?
Is absolutely the personnel change at the court. The court just a few years ago, the 5-4 court with Kennedy in the conservative majority, but not always voting with the majority. In fact, a third of the time voting with the liberals. That court was not in the business of these major statements, these major overrulings. But the Federalist Society really promoted judges who were quite hostile to Chevron. Justice Gorsuch, in particular, on the 10th Circuit, wrote an enormous concurrence explaining why Chevron was wrong. It was almost an audition piece for the court. And so you might even say that the conservative legal movement to deliver major social issue victories for the right in order to have some cover for doing what they really cared about, which was to undermine Chevron and attack the administrative state. So the answer to your question, Kurt, is I think once you had 6 conservative justices, once Amy Coney Barrett replaced Justice Ginsburg in 2020, they had the bodies, and the two cases, Loper Bright and Relentless, were, I mean, so marvelously curated, had such terrific facts for that side of the argument. Just to rehearse the facts for a second, because the plaintiffs are so sympathetic. These are herring boat owners who have to carry government officials to monitor their work to prevent overfishing. And to hear them tell it, and I visited with some of them in Cape May, New Jersey, they're happy. They like to have the monitors. They don't want overfishing either. They want good data, and they welcome the government monitors. But the relevant agency wakes up one morning and is short of funds, and it decides, not only do we want to put monitors on your boat, but we want you to pay for the privilege. And whether the statute allows that or not is ambiguous, I guess. The Third and First Circuits both said essentially, yeah, I could go either way on this, but the agency says it's okay. So Chevron, so we bless it. And It's the beauty of this case is that it's like so trivial in a sense, the actual question before the court, and so easy to understand and so beautifully presented. And the lawyers who argued the cases on behalf of the challengers, Paul Clement and Roman Martinez, really, you know, superstars of the Supreme Court bar. It was presented to the court on a plate. It didn't seem like an especially organic dispute. It seemed like something that had been maybe cooked up is too strong a word, but carefully curated and presented to the court.
I was hoping, Adam, for a fishing analogy there. Maybe it was a very small fish that became a marlin. I'm not a fish. I don't know how to best translate that.
Let's think about it as the minutes go by. We'll come up with some fish metaphors.
Great.
Well, so now we are in this world.
They reeled that in.
Nice. Now we're getting there. All right. So now we're in this post-Loper Bright world. Chevron is dead. And you talked earlier a little bit about sort of waiting to see, what will be the impact over time and how we need more data points really to understand how, I guess on the one hand, Congress is going to deal with it in terms of, writing new legislation, but how the agencies are going to deal with it in terms of things they can do. I guess I wonder in the near term, right? Because I agree with you. There's a wait and see, but in the coming months, what should we expect to happen?
Many challenges have been filed. The decision itself says individual earlier decisions that had upheld regulations based on Chevron were not themselves thrown out. That the baseline in those cases was there's not a stare decisis challenge necessarily to every single earlier decision, but lawyers are clever and there are new regulations to challenge. And as I say, I think we probably need like 18 months for fresh litigations to work their way through the courts, for summary judgment to be granted, and maybe some appellate decisions. But we'll have a picture soon. While some sober-minded academics and Justice Kagan at the Ninth Circuit also said, let's be cautious, let's see what's going to happen here. But certainly the regulated parties are dancing in the street. They think this is great for them. The pro-regulation consumer and other lobbies think it's going to be devastating. So they may be, on the one hand, falsely happy or alarmist, but on the other hand, they probably know what they're talking about. And it's probably going to have a huge impact, but it's just a little too soon to say that definitively.
Well, I like, Adam, that you've prefaced this next question by saying it's too soon to decide definitively. What do you think about the cases that are coming in the next term, in this current term, related to administrative agencies? I believe there's cases with the EPA involved, as well as the FDA, especially RJ Reynolds, and an NRC case, along with a bunch of criminal cases from the DOJ, the U.S. Attorney Office perspective. So ignoring your comment that we need to wait 18 months to see how all this plays out, how do you see things changing in the next few months here with the current term?
So this term, unlike earlier ones, is for now at least relatively sleepy. And that may change if we get some election case, gender case coming up. I view the ad law cases interesting, important, but minor in the scheme of things. The EPA case is brought by San Francisco, of all parties, against the EPA, challenging an EPA regulation which seeks to make sure the water surrounding San Francisco, the Bay, is clean. And San Francisco says, we agree with you, but you got to tell us what the standard is of what we can discharge. And the EPA just wants to say, we'll tell you the goal. And many people are discharging into the Bay. We're going to tell you the goal of how clean it's got to be, but we're not going to tell you directly how much you may discharge. So what's interesting about, I think San Francisco probably wins. I think this court wants agencies to be precise in what they tell people to do. But the very fact is that if you have like the bluest city in the country suing the EPA, tells you that's a somewhat idiosyncratic case. And then there are cases about disposal of nuclear waste. And there, the congressional statute may well not authorize the Biden administration to dispose of nuclear waste as it would like to in Texas, because and I haven't, some of these cases I'm going to talk about kind of generally, because until the arguments, I tend not to really take a bath in the
Of
briefs.
course.
But there's a sense that Congress has authorized disposal in two places only: the original nuclear reactor and the Yucca Mountains, that you have to read the statute fairly broadly to allow disposal in other places. And then there's a case on whether the FDA has the power to regulate candy flavored vape materials for minors. And, so that's a kind of hodgepodge of fairly ordinary ad law cases. I don't think these are real Chevron cases.
Yeah.
These are really cases that ask the question, does the statute authorize the agency conduct? And I don't think there's the intermediate question in any of them, but I may be missing something of, did the agency interpret the statute in a way that we have to consider or used to have to consider whether to defer to?
I do want to focus a little bit more narrowly on the SEC with just a couple of questions. And of course, one of the blockbuster cases from an SEC perspective that's come out over the last year is the Jarkissi case, and we mentioned it earlier. And I wonder if you can sort of help us settle a difference of opinion, not between Chris and I, but that we see playing out, in the media, in law firm client alerts and things like that, about how broadly or how narrowly to read Jarkissi, because there's a reading of that case that is potentially devastating, not only for the SEC and its reliance on administrative law judges and administrative proceedings, but for a number of agencies that rely on a similar proceeding or similar, administrative judges. On the other hand, there's a reading of that case that's sort of narrow to say, well, yes, this applies, but maybe only if we're talking about fraud charges, or maybe only if we're talking about cases in which the agency is seeking civil monetary penalties, or maybe even only cases where it's a fraud charge and they want civil monetary penalties. You can kind of, do a little bit of a pick your own adventure based on the charging decision. So I guess, I wonder, as someone who follows and writes about the court, how should we read it? What do you think is the intention of that decision?
Let me turn this around and ask what you guys think, and then I will try to develop my own theory. But you guys are in agreement?
I actually don't know what Chris thinks about it.
So let me again pass the buck, as Adam just did, back to you, Kurt, for your interpretation.
Listen, I tend to read it the more narrow way, that it probably only applies to cases involving fraud charges and or civil monetary penalties. But that's because I happen to be a person who thinks there is some value to the administrative proceedings for the agencies in terms of managing their own docket, in terms of giving defendants actually an option in some cases to do things a little bit more quickly, quietly, and cheaply. So maybe that perspective colors my view, but I would tend to read it somewhat more narrowly than some of the sky is falling pieces that I've read.
Well, so I think the music of the decision, and it sounds like you've read it more closely than I have, and I haven't read it since it was issued. But the music of the decision is, if it feels like a court case against an individual for money, that's not a public right, that's a private right, and that ought to take place in court. Now, I haven't thought through, Kurt, why fraud is different from other kinds of causes of action. What else does the SEC, what kind of action does it bring not in fraud that maybe Jarkissi doesn't apply to?
Yeah, I mean, there are a number of things that they can do that have to do with compliance with other regulations or rules. So registration requirements, for example, you could bring a simple case that says you failed to register as an investment advisor or broker dealer or an associate, or maybe you just failed to file some form.
And the relief the agency is seeking then is a fine, or simply a declaration or an injunction that the form be filled out?
Well, in today's AP world, there are a range of remedies that the agency could seek. It could be a cease and desist. In some cases, it could involve, some kind of bar or suspension. They could seek a penalty in circumstances they deem appropriate. So that's a little bit of a facts and circumstances, but it's not restricted to one type of remedy.
Yeah. So as I think about it, I think the lines you're drawing make sense. I mean, after all, the Seventh Amendment talks about you get a jury trial if the amount at issue is $20, which I guess was real money at the time of the founding. But that gives you the sense that it's a case like that you might bring in court to get money from a wrongdoer or get reimbursement to wronged people from a wrongdoer. So probably the answer is it's not as broad as some might think, but still a change, and also quite disruptive, because the only way all of this is going to be figured out is people are going to challenge the proceedings. And if I remember right, the court not long ago said that you don't have to go through the proceeding to challenge the nature of the proceeding. You can go to court to challenge the constitutionality of the proceeding as such ab initio.
I guess, Adam, as we look to close today's discussion, our bailiwick really is around that Securities and Exchange Commission. I've not kept up on kind of the lower court rumblings over the past few months. I know, Kurt, you're probably a little closer to that than I am. Adam, anything you're seeing that we should look for coming down the road that might relate more to what the average inSecurities podcast listener is interested in?
Well, I don't know whether you view as a wholly different area private securities litigation. But in November, the court will hear 2 cases involving tech giants accused of securities fraud in class action settings. And of course, the court is hostile to class actions, hostile to implied private rights of action. And so we'll see what happens in these 2 cases. One of them involves Meta, the parent company of Facebook. And the claim is that Facebook disclosed a risk generically that its data could be misused, even as it knew that risk was not theoretical, but had actually happened when Cambridge Analytica captured and used Facebook data for, among other things, to help Donald Trump get elected in 2016. So as a disclosure of a category of possible risk good enough if the actual thing had transpired already? And then NVIDIA faces a class action over and the question is whether the plaintiffs had adequately pleaded the securities law infraction there. So that may be a different zone from you, but those are actually the securities cases
Of course.
I'm more comfortable with, because that was, when I was a young associate, that was the sort of thing that looked like familiar litigation to me.
No, I mean, they're always of interest because I think there's certainly an overlap, and often one informs the other. If you're thinking about the bounds of, like a 10B style pleading, I think you're going to find similar approaches, whether I'm, against the SEC or in a private securities litigation context, in terms of what the courts are going to expect me to plead, or what a defendant can do to push back on a complaint. So they're always very helpful, I think, in terms of setting bounds or helping better understand the requirements under those securities laws.
Excellent. Well, Adam, I mean, we could be on with you for the next few hours, just peppering you with your take on recent court cases, your feeling about the court, as well as what we might see down the road. We really appreciate you taking the time to chat with us a bit about securities law that I'm learning about more every day. Kurt, I think you already know everything about it, so
hardly.
More informative for one co-host than the other. Adam, thanks so much for joining us today.
It was a lot of fun talking with you guys.
For those of you interested in more from Adam Liptak, you can follow him at the New York Times or listen to one of his many appearances on The Daily podcast from the New York Times, as well as other outfits. Thanks for joining us for this episode of the inSecurities podcast, and a special thanks to our guest, Adam Liptak of the New York Times. We always love to hear from you, our listeners. Look for us on social media to share your thoughts, comments, or topics you'd like us to explore on future episodes of inSecurities. Please use the hashtag inSecuritiesPod on X or LinkedIn to join the conversation. You can find me at EcomoffCPA.
And I'm at Enforce_update.
Don't forget to subscribe, rate, and review the inSecurities podcast wherever you listen. Be well, everyone, and we'll see you next time.
Thanks for tuning in.
Thanks for listening to inSecurities, a podcast from PLI, the Practicing Law Institute. PLI is a nonprofit provider of authoritative professional services training and continuing education. In an increasingly complex business environment where intricate corporate structures reign, inSecurities can help you make sense of it all. A special thanks goes to the producer of inSecurities, Daniel Pinitz, as well as hosts Chris Ekemoff and Kurt Wolf. For more information about PLI's SEC Institute, or to view hundreds of hours of fresh and relevant on-demand programming covering changes within the securities sector, visit pli.edu/membership and sign up for a privileged membership. These recorded materials are designed for educational purposes only. This podcast does not constitute legal, audit, tax, consulting, business, financial, investment, or other professional advice, and it does not create an attorney-client relationship. Please consult a qualified professional advisor before taking any action based on the information herein. Furthermore, the views and opinions expressed in this podcast are solely those of the individual participants. These views are not the views of the hosts or their employers. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission from PLI.